Namaskar, I am Assistant Professor Kritika Dev from LJ School of Law. Today, I'm here to again deal with a very interesting but at the same time very important topic of Indian Penal Code, and that is Section 354, outraging the modesty of women. Yes, you heard me correct. The section talks about outraging the modesty of women. This seems to be a very interesting topic, and of course, it involves so many elements in it, which will be clear with the help of the case laws that we are going to see in it, and in detail, the definition of each and every ingredient involved in it. So now, let's see the definition of Section 354. The definition says that assault or criminal force to women with intent to outrage her modesty. Whoever assaults or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine. We just now saw the definition of outraging the modesty of women, and I'm sure that in the definition you must have found very important and interesting terms, which are, of course, were open for the interpretation and are still open for the interpretation for the Honorable Court. Women, modesty, assault, and criminal force are the terms that we have seen earlier. So we might not discuss in detail about those two terms, but of course we will discuss about it. But women, modesty, intention, and knowledge, these are the terms which makes this section the section it is now. Now let's go to the ingredients of the section. And the ingredients are, we'll see the first one, use of assault or criminal force. Women, as I said, intention, knowledge, modesty was likely to be outraged. So these are the ingredients which we will be discussing in detail today. So let's quickly move on to the very first one, assault or criminal force. So here in the previous lectures, we had gone through what assault is and what criminal force is. So here, it could either be a criminal force or assault. I want to make it very clear, not only criminal force or not only assault, the section has both the ingredients. Of course, there is an or in it, but it says either criminal force or assault. So even if there is an apprehension, in assault we have seen there is an apprehension that the criminal force will be used. And criminal force, of course, is use of that very force. So here, criminal force or assault, as it is the ingredient, if these are being used against a woman with the knowledge or intention that it will outrage her modesty, then it will amount to, or that person will be booked under Section 354. Now let's see the other ingredients. Women, a very strong and bold word, women. Who's a woman? Now that was completely open for interpretation. But here, in order to get a clear idea, we will see the definition and also what was held by the respective courts. Because you can see this is a term which is somewhat, very strong. Women. Women under IPC Section 10 has been defined a human being, a female human being of any age. Though it was defined under Section 10, but every court had a different interpretation of the word, and let's see how it went. Now, this is a very important, interesting case, that is Emperor versus Tatya Mahadev. Now, let me tell you the brief facts of the case. In this case, the accused took a 6-year-old child to a room. Yes, a child of 6 years to a room, and then he tried to lie down on that very young lady. Now, as soon as she realized, she just stood up, she screamed, and she ran away from the place. Now, these are the facts of the case. Now, the lower court said that the accused should be, or the accused was held under Section 352, but not under Section 354. The court said the girl is too young to have the modesty of a woman. But later on, the case went to the High Court, and the court held that the act of the accused was punishable under this section, that is Section 354, for the girl, though young, was a woman as defined by Section 10. So here, the higher court said that though the girl was young, but that does not mean that she will not have her modesty, or that does not mean that she will not be considered as a woman under Section 10 of Indian Penal Code. So the court held, irrespective of the age of the women, though young, though old, a woman is a woman, and every woman has a modesty. The next ingredient is intention or knowledge. Yes, intention or knowledge. So there could be either intention or knowledge, and if there are both, then of course that forms an ingredient under the section. But intention here is, for say, if there is a man with an intention to outrage the modesty of a woman, that is clear. But in case where he just says that I had no intention to cause or to outrage the modesty of that woman. But if he had knowledge, that itself is sufficient under this section. And now we will see some of the examples or some of the terms which were completely or which by the court held to be having knowledge or doing certain things or doing acts like this will amount to outraging the modesty of a woman, like placing hands on the shoulder of a woman, putting hands on the belly of a woman, holding on the wrist of a woman. But here, I would like to gain your attention that the term modesty, it differs from women to women. It differs from the lifestyle of a woman. For some females, it might be okay if their friends touch on the shoulder just like buddies. But for some females, that might not be the case. So here we'll see that the term modesty, or how to interpret intention or knowledge, or how to actually see whether the accused has the intention or knowledge. So this is completely, it differs from case to case, and the court is of course completely has to use a wider vision to see this very ingredient, whether the accused had the intention or knowledge or both. Now let's see what is modesty. Modesty is being interpreted by the courts in different manners. So here, let's see what the term modesty says. Now let me tell it to you that the term modesty has not been defined under the code. It is not there been defined under any section that what modesty is. So, in order to get the clear idea what modesty is, it is very important that we see this very section, apologies, to see this very case law, that is state versus Major Singh. Now what happened in this case? In this case, there was a child of 7.5 months. Yes, there was a child of 7.5 months, and the accused tried to do something with the private parts of that child. Now, what happened under this section, or what the court held under this section, that young or old, intelligent or imbecile, awake or sleeping, the woman possesses a modesty capable of being outraged. Whoever uses criminal force to her with intent to outrage her modesty commits an offense punishable under Section 354. Now, yes, before Justice Bachawat stated this, or the majority of the judges defined what modesty is, the lower court said that, of course, this young child had no modesty because he cannot be termed or she cannot be termed as a woman. So, there, the court said that the girl child had no modesty because to have a modesty, a person must be capable to realize or to feel that her modesty is being outraged. And that was the reason with majority judges taking the judgment by saying that whatever may be the age, whether the female is sleeping or awake, or whether she possesses the capability to understand whether her modesty was being outraged or not, the accused will be booked under this section if he had outraged the modesty of a woman. With this, let's move on to the very famous case of Rupan Deol Bajaj versus Gill KPS. This is a case which was very famous and which involved very two strong parties in it. Now let's see the facts of the case. In this case, there was a female IPS officer. Apologies, she was an IAS. The person, Mr. Gill, was an IPS. Now, what happened under this case? They both were there in the party where there were female IAS officers and other officers as well, and Mr. Gill, KPS Gill, was also present there. Now, he went to those group of IAS female officers, and there the victim was standing, and he just slapped on her posteriors. Now, under this very case, the court held that it was under this very section and he outraged her modesty by slapping on her posteriors. The Supreme Court held the Supreme Court held that slapping a woman on her posterior amounted to outraging of her modesty within Section 354 and Section 509 of Indian Penal Code. So, by these landmarks and important cases, I guess your idea about the ingredients, the woman, outrage, intention, and knowledge must have got clear because these are the ingredients of which, if you do not have the clear idea or if you do not have the proper definition or the proper interpretation, then you might fail to understand this very section. So now let's move on to the next slide, which says that what was the scenario before the Criminal Amendment Act 2013? What were the punishments? And what happened after the amendment? So before the amendment, the punishment was, or you can say the imprisonment was, of either description for a term which may extend to 2 years or with fine or with both. So here, whenever the term which may extend to comes, then it says that the maximum punishment should be 2 years. The minimum could be anything. Could be 10 days, could be just 1 month, could be anything. So when the minimum is not being defined, then the minimum can be anything. But after the Criminal Law Amendment Act 2013, the punishment says that it shall not be less than 1 year. So here, after the amendment, the punishment in no case can be less than 1 year, but of course it may extend to 5 years, and the accused shall also be liable to fine. So here, earlier we have seen that there could either be a punishment or fine or both. But here we are seeing that the punishment will be there and fine is just not an option. Fine has to be there with the punishment, which has to be more than a year because it shall not be less than a year, with a proper amount of fine. Of course, the amount of fine is up to the discretion of the court, and this is in before the amendment. This was an offence which was cognizable and bailable, right? Cognizable and bailable, but after the amendment of 2013, this had become a cognizable as well as a non bailable offence. So, yes, these were the important things or were the result of Criminal Law Amendment Act 2013. I hope Section 354 is clear in your minds. We are clear with what a woman is, what her modesty is. It may, of course, differs from case to case because every woman has a different level, or you can say a different way of seeing her modesty. So that is completely, or you can say it may differ from case to case. But we have seen some landmarks cases where what modesty is being defined, and coming to modesty and women, it includes all the female, irrespective of their age or irrespective of that very fact whether they were aware, they were sleeping, or they are of a very tender age, or they are very old to realize it. But yes, if they have harmed the modesty, the person, the accused, will be charged under section 354. With this, I would like to rest my lecture. I hope you must have got the terms, you must have got the section. And with this, I would like to take your leave. Thank you so much for listening, and take care. And of course, keep studying. Have a good day.